Hello, everyone. I have with me today a guest who's been on the channel previously, which is Lulu Minns. I'm just going to do a short introduction because I've done a full biography of her previously. She works as a coach of women, and what we're particularly going to be talking about today is that she was a solicitor for many years and has worked on many criminal cases. So, firstly, I say hello to Lulu and thanks again for joining us for a second time.
Hi, Chris. Good to be back. Thanks for having me.
No problem at all. So, I have no idea when this is going to appear on YouTube, so this may not be the most timely discussion by the time that it does appear. But as I'm recording this, yesterday, the Crown Prosecution Service has announced that it will not pursue what I certainly consider to be frivolous charges in relation to Lucy. So the first question I'd like to ask you, Lulu, is just simply, what was your reaction to this news, and do you have any thoughts on this?
Yeah, absolutely. I mean, I'm not surprised because of the way that the tide is turning and seeing the public reaction to Lucy's case. There were some ridiculous posts over the Christmas period about, what she may have in prison and, privileges and all of that kind of craziness. And I was just out of interest looking at the comments underneath of the public saying, that they believe she was innocent. And I think that really has an impact because the Crown Prosecution Service have to, ask whether there, is sufficient evidence for that matter to go to court and whether it's in the public interest as well. So they are probably in no doubt that the tide is turning, and a few people sent me the news report yesterday because they know that I've been talking about it, prior to her being convicted. So it is as good news as Lucy has had throughout the beginning of this case, which has gone wrong right from, the first accusations by the hospital through to the trial and so forth. And also, as we discussed last time, we were talking about the some 30 interviews that she had prior to her being charged and taken to court and taken to trial. When I was doing a bit of research around that, I think the last I found, if this is true, that she was last talking to the police in December 2024. And that, again, as a solicitor with over 10 years' experience in providing legal advice at the police station, caused me real concern because the police were, as we know, fulfilling their hypothesis of confirmation bias from the off. And I knew that hadn't changed. And obviously it hadn't because they then sent the whole files to the CPS in July and they've taken this long to review it. So yeah, I'm pleased that the tide is suddenly turning and there may be some sense now, we hope, to moving this case forward and the appeal with the CCRC and back to the Court of Appeal, fingers crossed.
Hmm, I agree entirely. I want to ask you as well, you've obviously, have you dealt with the Crown Prosecution Service before in
Oh
your
yeah,
career?
many times.
Yeah, I assumed that you would have done. So,
Daily,
yeah,
daily.
yeah. So, I listened to, I don't know if I've mentioned this previously on video, but I listened to Five Live yesterday, and obviously it's the BBC, so they gave the most, let's be generous and say neutral reaction to this news that they could. But even on Five Live, the reporter for BBC Radio said it's very unusual for the police to kind of bite back against the Crown Prosecution Service. So I just wondered if you had any reflection on that and what you thought of the police statement.
Yeah, I agree. From a professional point of view and cases that I've followed in the press over the years, and there were many years that I wasn't following any, as I explained last time, from when I left legal practice, but I've been much more interested again over the last couple of years, and they're usually a united front. So I wonder where that's gonna turn in terms of the relationship between the police and the prosecution, because when this case unfolds, which you have been saying, I've been saying, many people have been saying, that the system itself needs to be held accountable for numerous systemic failures that are likely to have taken place in this case. you know Again, it's like bad families, isn't it? Everyone starts pointing the finger of blame instead of actually looking at the system as a whole, and that's what needs to happen. So I would agree that it's unusual for them to be sitting in different camps at this point. But again, I'm not overly surprised given the magnitude of what can happen from here
Oh
on in.
yeah, yeah. It's a skin-saving operation now, isn't it?
Yeah. And we've got the medical, we've got the NHS, we've got everybody, all the big systems that we rely on here in the UK, which are absolutely in crisis. And underinvested is not the only issue. Systemically, they're not working. There's not enough responsibility, case management, accountability, all of those things. They're not fit for the 21st century, in my opinion. Need to belt up and do better. And they're not gonna, they're not prepared to do that yet, because it's such a big issue. Where do you begin to start solving it?
Yeah, yeah. Um, we were discussing this a little bit before we started recording, so I think this is a difficult question to answer, and I don't mean to put you on the spot, but what, why, apart from what you've just mentioned, which is the magnitude of what is being dealt with here and the consequences for these organizations, why do you think, why do organizations and institutions find it so difficult to take responsibility and to say sorry or just to accept that they acted in a way that was incorrect or inappropriate or whatever it might be? Do you have a view on that, or do you have any particular insight?
Yeah, I think, and it's something that I've looked into over the years. And I did a systemic constellation 120-hour course, 2 years ago. And it was very interesting talking about how systems attend to survival, and that they will sacrifice individuals in order for their the survival of that organization or that system. So again, we see that in families. Everyone starts pointing the finger of blame at one particular person, and organizations are, they want the system to survive as a whole piece. So one little person, one human life,
Mm,
just just to what's the wording, to preserve the perceived integrity of that system
mm,
as a matter of survival is seen more important than the truth or accountability. And it's something that's subconscious and kind of underneath, when people are maintaining that system. And there's something about Lucy's
mm.
case that I was gonna conclude on for today, but I'm gonna share it now. I find it really interesting that her case, it was in 2022, wasn't it? I keep 2022 and 2023 keep getting caught up in my mind, but either way, it was after lockdown, and in lockdown, we were all told that the NHS were heroes and we needed to clap for the carers. Now, on an individual level, that's absolutely true. And 99.9% of all staff that work for the NHS are absolutely incredible. It is a vocation, it is all of those things. But actually, the system as a whole, it is wholly dysfunctional, as a lot of the criminal justice system is at the moment. And, it's trying to blindside us into continuing to throw taxpayers' money at these systems that are mostly dysfunctional. And I bring that up because I think that probably contributed, amongst as many other issues and systemic failures, to Lucy's conviction. Of course, even the public, of course we want to believe that one person has gone rogue rather than a multitude of failures, because that puts us all at risk.
Yeah, absolutely. And that's why it's so important. One of the many reasons why it's so important is this is a story about patient safety
Yeah.
in the national healthcare system. It's as
Yeah,
simple as
and that
that.
they were going to be sued by the parents of
Yeah.
the babies on the first account. And again, through your channel, and it's quite normal for a lawyer to do that, working with the NHS, is saying, oh, it's cheaper if she sues us for constructive dismissal. Let's just, law firms do the same. Let's
Mm,
get rid of the person to maintain the integrity of the system as a whole
mm.
and to save ourselves some money. And that's how organizations unfortunately work. But I think we have to be more aware of that, in moving forward and evolving as a human race. We can't
Yes.
bury our head in the sand about it. We've got to move forward.
No, absolutely, absolutely not. Um, so we're going to talk about some of the specifics of Lucy's case today as well, and some of the legal issues. So we're going to begin by discussing the note, the infamous confession note. Um, and we share something on this topic because you told me that this was a big early red flag for you, as it was for me. So I just wanted to ask you firstly, what specifically about the note makes it weak or unreliable in your opinion?
Yeah, it was. I remember first seeing it, I think, it was printed on the front page of lots of newspapers and things like that when, halfway through the trial, it piqued my interest. And I just thought, how ridiculous. What else does it say
Hmm.
rather than that, one thing? I think it's the I am evil and I did this, I not being good enough, which again, from a coaching perspective, when people are under psychological pressure, external life experiences, divorce, I've dealt and worked with women going through toxic work situations, frequently. We and this is men and women, although women can have a tendency to do it more, I would say, is internalize certain things that are happening. And the biggest belief that all of us have is that we're not good enough. When something happens on the outside, it's again, it's subconscious, it's buried within, that in some way, shape, or form we're not good enough. And when we're under pressure, or and you get support, which I understand Lucy had support on advice of the hospital, then those beliefs, it's bringing all the stuff to the surface, all those emotions to the surface. And emotions need to be processed and moved through, but many of us live our lives keeping them on the surface level because it's much easier to do that. And when things like this happen, it all has to come up to the surface. And writing, keeping a journal, keeping notes is something, is a way to do that, and to move through that. So that was my first instinct. I didn't know she had a counsellor or was getting support at that time, but it just indicated that it was a way of processing what was happening. And it seemed quite obvious that there would have been a work situation, culture thing, investigation happening way before the police went to her address and arrested her, and seized that note, which is also why they arrested her, so they could had a warrant to pull out all sorts of things from her address and make them more significant than they actually were. But we'll get to that later on. And so they were my first instincts. And then secondly, as I was looking at more miscarriages of justice, or cases also including where women have been blamed for things, it's interesting how often notes and diaries have been used. Kathleen Folbig, I know she's been mentioned on your channel before, the case in Australia where she spent 20 years in custody, for um, allegedly, harming her four children, which again, we have the genetic reasons as to why that happened.
Yeah,
A
I think, can I just emphasize at this point as well? It's really important to emphasize with this case that the medical evidence was very flimsy indeed. And they really used their diaries very strongly in that case, like more strongly than Lucy's case, because
Yes,
there's nothing in Lucy's note, as we know. So they couldn't use that, even though they did use it as a substantial part of the trial. But Kathleen Folbig wrote very extensive, quite detailed diaries, and she really was essentially convicted based on her diaries. And also, when they appealed the case the first time and she lost the appeal, they basically lost the appeal because the judge and the whatever the equivalent is in Australia of what the appeal court would be, they said, yeah, this is all great, all this medical information you've given us, but she confessed in the diary, thanks for coming, she's staying in prison. That's absolutely true. Because
yeah,
when I
yeah,
was
yeah,
in London, they said,
yeah,
the lawyer who represented her said, I walked into the Court of Appeal room and I got a bad feeling immediately about what was going to happen. And she knew they were going to fail the appeal, and they basically failed it on the diary. And then they had to spend ages getting people together so that when it's 10 years until they got another chance. And they had
yeah.
to make sure they had all the diary stuff. So I just wanted
Yeah,
to
and that's because the courts don't know how to process self-blaming,
Mm,
and any woman who's lost a child will tell you
mm,
that she blamed herself in some way, shape, or form. That's even with miscarriage, oh, if I hadn't have done that thing, then that might not have happened.
mm.
That is so common, but it's never put forward in cases for that reason, which, is just shocking. And I know as well, but I don't think it was put through in the case for Lucy's, that there was potential. I think it was in the police video you said of coding, and that's been used before in the divorce case in the 60s in the UK of the Duchess of Argyll. Um, Her husband, the Duke, stole her diaries, put it into divorce proceedings, and she was accused of being a wholly immoral woman by the judge because there were little X's or marks in her diary. The court decided that was her having rendezvous with various men, right? That wasn't even what was written in there. They
Mm.
just decided that's what she was doing. And it's almost like trying to interpret women's words or diaries is a little bit, and I mentioned the witch trials last time, it used to be women's bodies that were interpreted, of like finding the witches marks and examining women's writings. It's quite similar. And the court is a male dominated system that doesn't always create the space and understanding for what a female experience, what a woman's experience may be. And that's not totally exclusive to women, because many men have diaries, and many men who might find them in a similar selves and similar position to Lucy would probably have a counsellor, and counsellors and coaches say, write this stuff down, process it, because you have to move it through. So
Mm.
it was it was interpreted in a way that's not trauma informed as well,
Mm.
which I know we talked about that last time. So, and it needed context, and of course the newspapers didn't give it context. And then, lo and behold, the court didn't give it a lot of context either. It was interpreted through quite a court and male dominated lens of a woman's words.
Mm. Something I'd like to add to what you said regarding the kind of male-dominated nature of the system is another important thing to remember is that we would all hope, and I think we'd all agree, that the situation has improved from the historical situation, but the system is still, in this country at least, very much based on a time when our social act. I mean, women didn't even have the vote at this time, and I challenge everyone, everyone who's watching this at some point, you should go and look at the history of the British court system because there are articles written on this. And you see from like, I don't know, it might begin in like 1400 or something, whenever it begins, it doesn't really matter. Going back hundreds of years, there's this very rich history of all these things that happened. And then it gets to about 1870, and that's the last development. There's one more thing that happened after that, which is the Court of Appeal was formed. I think it was in about 1920, roughly. I might be slightly wrong on that. Don't quote me on that. But literally, it's the same system from 1870 when women didn't have the vote, as an example. They were still absolutely second-class citizens, and yet we're still operating. Of course, this is one of many issues. This isn't the only issue with having a system that dates back to 1870. There are many issues, but it's one thing that I wanted to highlight is that we're still using this antiquated, and that's not me, that's not my words. Just go and look at the official history of the British court system.
Yeah, and we
And
have to we have to take that in context of what, and I'm not saying there were certain things that Lucy wasn't talking about. It was more that she probably didn't fully understand her own emotions. So how much explanation could she give it herself? And we see that historically. I mentioned the case of Edith Thompson before, her love letters being used, that were romanticizing and fantasizing and had no nexus to the crime that took place where her lover killed her husband. And but again, there were lots of things she came across badly, in inverted commas, in evidence, because there were a lot of things that she couldn't explain or talk about, which were things that weren't socially accepted for women at that time, including having an affair with a younger man. But also, abortion, miscarriage. Same with Duchess of Argyll. There's an indication that she was hanging around with a lot of homosexual men. It was illegal at that time, so she didn't want to throw her friends under the bus, in a court of law. So the courts are reflective of the times that we're living in. And at the moment, even in the last, probably, as I was just talked about lockdown, I think even since then, the words trauma and being trauma informed are suddenly much more common language that people are using. We're aware of the things that we have going on, and the courts need to be up to date and move things forward in a way that is modern and not archaic.
absolutely. So we also both agree that the defense did a pretty bad job on the so-called confession note. So let me just ask you a couple of questions about this. What tactical steps should the defense have taken to neutralize this? And if you were the solicitor on this case, what would you have done and what would you have advised the barrister to do?
Yeah, and there's an interesting dynamic between barristers and solicitors. You're hiring the barrister, and particularly King's Counsel, to be, they're the expert in the case. They're the expert in Crown Court trials and litigation and advocacy, and King's Counsel being the highest of that. And technically they can be brilliant, but that doesn't always mean they fully, and I'm not saying necessarily in this case, but understand the full context. And I think it is, and it should be, it doesn't always run like that. A lot of solicitors may send it to the barrister and they just crack on with it, but it should really be a collaboration. And there are times where myself and a barrister may disagree about certain things, but at the end of the day, I was the instructing solicitor, and you're kind of on the ground with the client, if that makes sense. You're almost the bridge between those two parts, where the barrister has got the institutional authority and a voice that works in the courtroom, and you're almost in some ways interpreting what your client's saying on a base level, and moving that through so the barrister can bring it across. So saying all of that, what the defence did do is apply to exclude that note, and that wasn't, I'm pretty sure they did, and that obviously wasn't accepted by the court. So the note went in, and I'm not unsurprised that that was an unsuccessful application, because there's all sorts of reasons you can keep diaries out, but I don't think that would have been the case here, because of the court's misunderstanding of alleged confessions or false confessions as well. So they applied to exclude it, that didn't work, and then I feel like there was an unpreparedness for how to deal with it in the trial. And I'm just surmising here, it is a problem for the defense, and I would say I would have been concerned about it, to address someone even on those two short lines that is potentially self-blaming from an emotional point of view, because what's going to happen is the prosecution is going to go for the jugular, right? The bigger deal you make out of it, or that you use the word self-blame, they're gonna go for your client. So I feel like it was almost tried to, like, watered down. We'll touch upon it, but we won't, we won't go too far with it. And of course, the defense did give it some context in terms of, I can't remember the language that was used, but that she was dealing with a highly stressful situation, etc., etc., etc. But the biggest issue is that there should have been an expert. I know we go back to the defense experts, a forensic psychologist, psychiatrist, maybe even a confession expert, which I'm not sure there are any in the UK. There certainly are in America. And there's a particular expert, I think he's called Brian Cutler, if I'm correct. And Lucy's current barrister has been talking about getting experts from abroad who he talks mostly about false confessions, that are forced by the police, in terms of the way that interviews were conducted and are conducted, which has changed a lot in this country since the Police and Criminal Evidence Act of 1984, and then miscarriages of justice that we associate with the Guildford Four and the Birmingham Six, and quite male-dominated miscarriages of justice. But I think an expert like that could have contributed here, because I was doing some research about his work, and he says that it's not enough for the defence to raise a reasonable doubt about that confession note, because juries just don't consider that. They're not trained lawyers. They don't actually look at reasonable doubt like we do. And I think I said last time when I was at law school, I thought people don't confess to stuff that they've not done until you're in practice and you see it, and you understand the psychological pressures that people are under. And he said, what the defence have to do is go on the offensive and actually attack it and use that note as evidence of innocence.
It's
And
interesting. It's interesting you say that, because I've always felt they've got to tear this up. They can't just, like, oh well, what were you thinking what were you feeling when you wrote this, and what were you feeling when you wrote that? They should have been hammering it like a sledgehammer. Look what is actually written in this note. This
yeah,
note is a joke. This note is not an item of evidence. They just need to embarrass the prosecution almost, I feel. But
and it was almost a bit polite.
yeah.
And I think that, and I do get it from when I was in practice, and obviously I left 10 years ago, so there's lots of doing coaching, as I said, you learn stuff more and more, in terms of lots of different aspects that I think is very useful. But I can see what the fear was, with the prosecutor as fierce as another King's Counsel Nick Johnson was. So, and I know we're going to talk about the cross-examination, the more the defence made of it, because Lucy would be giving evidence with her barrister first, right? Then the prosecutor stands up, and we'll talk about the way that was structured. That's what he would have gone for. So I can see, but again, I feel like it was a bit of an old-fashioned way to deal with it,
Mm.
and not quite bold enough,
Mm. Mm. Um, so at some point, Lucy's barrister, I don't know if Lucy's solicitor is there, but it seems like it'd be a job for the barrister, is meeting her in prison because she's incarcerated from 2020 up to the trial.
Yeah.
And they're having meetings with Ben Myers. So presumably he is giving her instruction and even coaching her on because they decide we're going to put you in the witness box. That's already a tough thing to do. So presumably the barrister is coaching her or saying you need to do this or you need to do that. So how hard is it to do that under any circumstances, and how hard is it to do that with someone who's in prison?
Yeah, I mean, you can't coach your clients in terms of how to give evidence.
Okay.
No, you can't do
So
that.
what does happen? What does
You
happen?
can prepare them. I mean, what would have happened? There would definitely be conferences with both Lucy, her barrister, and her solicitor. Prior to that, the solicitor would be, getting instructions from her, putting that in what we call a proof of evidence and sending that to the barrister. And then there's conferences on that. And you can certainly tell clients what to expect, the order of how the evidence is, and, the types of things that the prosecutor will go for and attack, and you can, challenge and check, what your client's evidence is. I again, I think because they, and I'm surmising here, I just don't think a conversation was deep enough about what those notes actually meant, and
Mm,
in fact it may be that it didn't need to be. An
mm.
expert should have been looking at it.
Yes, yes. I just
Line
felt
by
because
line.
I've read through the transcript where they discuss the note where Ben Myers interviews her, and I just feel that they didn't make the points forcefully enough. It was just, oh, I was feeling a bit sad. I was feeling a bit. It was all wishy. You said I forgot what word you use now, but I would describe it as wishy-washy, really. Um,
Yes.
Whereas the prosecution come on and go, why did you say? Why did you do that? It
Mm.
just seemed weak.
Yeah,
Which is
polite. It was
yeah, that's
polite.
the polite. Yes.
Yeah, it wasn't. Yeah, it wasn't really given that depth, and I think, that was, part of a deliberate strategy potentially that backfired.
Okay. Okay. Well, that's interesting. So I'm going to go on to discuss this blue post-it note. So I'm going to share my screen.
Yeah.
Hopefully this is going to work. I'm always slightly nervous when these things happen, but we'll see how it goes.
Yeah. Well, and I was
Uh,
going to say, what we don't know is that the defense may have tried to get an expert, and, they weren't very good and didn't pull it apart enough
right.
so they could rely on it,
Right.
So that's happened, and that could have been the
Yeah,
case.
we don't know. We don't know. I mean, I don't think they did, to be honest, but
No, I don't
we don't
think
we
they
don't
did.
know for sure. We don't know for sure. So I'll share my screen, hopefully. Here we go. And this is the blue post-it note. So this is still a very unpublicized aspect of this case. And the only useful thing the BBC have done is publish this document because no one else has published it and they haven't done anything else useful. But in this document, I'm only going to show the first half. There's this statement from Lucy, police naming me, obviously no evidence and would have been spoken to, but still upsetting. So I've always said, and I maintain, and then she's talking about other people supporting me how they can, but can't confirm 100% I didn't do anything. And then she writes, or anyone else. So I've always seen this as an exculpatory document because, firstly, if there was evidence, if she was guilty, she would know that there could be evidence. She wouldn't be writing to herself. Obviously, there's no evidence. This is not the way that a guilty person would write. And as for talking about anyone else on the unit, she wouldn't. If she was guilty, she wouldn't care about anyone else on the unit because she would know they were innocent.
Yeah.
So I just immediately saw this as something that could have been used in her defense, and wasn't. the only time I've ever seen it to this day is in the BBC article. So I was just wondering if you had any thoughts on that about whether, you know, why did Lucy's defense ignore it? Why wasn't it used in court? Do you have any thoughts about that?
Yeah, and it was the first time I'd seen it when you showed me prior to the interview. I mean, I don't know in a nutshell, apart from, the fact of it being a potential strategy to light touch the things that
Right.
she'd written down,
Yeah.
so we move away from the self-blame aspect, which I think, if that was the case, it is a mistake. And I think there should have been an expert going line by line by line by line by line, like experts do, which I think some of your watchers on the last one, with Laura Roberts, who's a crime analyst. I mean, she does, analysis of, male violence towards women, but she does these incredible analysis of, behavior. And there would have been an expert. I'm not saying they would have been easy to find,
Mm.
but someone to unpick, because, as I said, Lucy probably can't fully explain it all herself, because emotions are complex. You can't see when
Mm.
you're inside the bottle, and you're not an expert in your own, you know emotional processing. There are experts that deal with that, and they should have been part of the case, in my opinion.
The other thing as well is they go up and down, of course. So, you know, it takes an extraordinary person in any circumstances to be in the same level all the time emotionally. We have good days and bad days.
Yeah,
So,
from a coaching perspective, not to go too woo woo, emotion is energy in motion, right? By its very
mm,
nature, it moves and it changes and it flows, and it is not a consistent thing whatsoever. And it's a lifetime commitment for all of us to understand our own and other
mm,
people's.
mm,
It's the things that we don't see, and that's so important in defense cases. It's not what's there; it's what's not there.
yeah, absolutely. I want to ask you some questions about the trial, other questions. So, the first one is. This was an extremely long criminal trial. We all know that. It lasted for 10 months, but there were quite a lot of breaks, so the number of days in court is not as high as many people believe. But it was still nevertheless a very grueling process, and certainly for the jury, and certainly for Lucy. I don't think any criminal case should last that long. That's just in my opinion. And another opinion I have is that it was a clear strategy of the prosecution to drag the case out for as long as possible and make it seem that there was no smoke without fire. So I just wondered if you had a comment on either or both of those assertions, and what your opinion is.
Yeah, I mean, it certainly suited the press that it went on for that long, because the
Mm,
amount of newspapers that were sold and podcasts that were created and everything else,
mm,
I think it is the reality of, and I was talking to you before hitting record about an American case, Eileen Warnos, who was guilty of being a serial killer in inverted commas, although, she was a highway prostitute and probably, facing very dangerous and violent situations. But as she said, lots of people were making and profiteering off her case, and that wouldn't have been the intention of the court for sure. But what and it's not, interestingly, preparing for this, it's not the longest UK trial. That was a trial in the 80s, by a lady, the murder of a lady called Lynette White. Three men were convicted. It was an 11-month trial. I don't know if there were many breaks in that trial, but all three men were exonerated. So that's another factor of long trials don't equate to justice. And I think there is huge difficulty in how long and complex this trial was. And and how grueling, as we were talking about just now, potential confession, which wasn't a confession from Lucy. I mean, that was right at the beginning when she was just being investigated by the hospital. And I know we touched upon this last time,
mm,
but we've improved to some degree police interviews, although I don't agree she should have been interviewed 30 times. That, and the amount of days she was in the witness box cross-examined. I know we're going to talk about that in a moment, but 10 days of cross-examination, if not, I think, no, yeah, over a really long period. And I think she was evidence chief for 4 days. Within that time frame, I might add, when her cross-examination started, she wouldn't have been able to have any contact with her defense lawyers whatsoever. Because when you're in the middle of evidence, you can't, i.e., your defense lawyers can't go down and coach you and say, what you should have said is this,
Mm,
and all of that kind of stuff. That's not permitted. So the psychological pressure of everything, we certainly in this case, and we should be mindful of it in others, breaking down, defendants and their well-being in a different way to the police interviews. 10 months is absurd, and a lot of, I haven't broken it all down, far from it, but more admissions could have been made at the outset of that case, as we talked about last time.
mm,
The parents, awful for them losing a child under any circumstances. The result of this investigation and everything as well, even worse. But it was admitted by both sides in the case that they'd lost a child. So I feel like that had a big impact on how long this trial became, as well as, from your analysis, loads of people in the hospital going, we had no idea what was going on.
yeah, well, that's what it
What
is.
is that?
That's what it is. It's just loads of people in the hospital going, oh, we thought everything was fine, and then this baby died. That's a lot of the court case. You
Yeah,
know, there's in the media, understandably so. There's always an emphasis on the new medical evidence, to be generous to what Dr. Evans provided. Um, but that's a very small component. It really is approximately a sixth. It's just under, it's roughly a sixth, 1/6 of the whole process is them on, or it may even be slightly less than that. I think I'm right in saying I calculated it to be about 17%. And then off that 17%, 92% of that is Evans and Bohin. So the other witness, he always goes, "Oh, the other witnesses back me up." That's literally less than 1% of the court case.
yeah.
If you look at the time they were in court.
Yeah. But
So yeah.
we've kind of jumped. I was looking at Anne Boleyn's trial,
Mm,
1536 a while ago, and she was arrested kind of on the Monday in May. And then she was tried the following Monday, right? In half a
mm,
day. She had the afternoon, and they tried the men that she'd been cavorted with on the Friday. They'd already been convicted. So she was blatantly going to be convicted. Her brother was tried in the morning of the next Monday, and she was tried in the afternoon. So as we were talking about the archaic natures of trials, we've moved a long way, but I think there's massive danger now of them becoming so overcomplicated with text messages. Because as we know, I said to you, didn't I, last time, trying to listen to Judith Maritz's book, and then at 1356, this text message was sent. It had nothing to do with anything. The detail, the level of detail that was used meant over 10 months was like the whole big picture, and the systemic stuff was totally lost, in my opinion.
mm,
And I've dealt with murder trials with multitude of defendants. 6-8 weeks is a long time. Peter Sutcliffe trial was 2 weeks, but with technology now, there's reams and reams of text messages. It's almost like we're all overwhelmed by our inboxes and social media accounts, and trials are in danger of being weighed down by that stuff, and missing the actual point of a lot of the trial. And I just wonder how that impacted everything.
mm. I remember I watched this video some time ago now, and they were saying it was something like they were saying the amount of information that will be generated in the next 3 years is more than all of human history up to this point, because of the amount of information sources that are available now. But I watched this video a while ago, and the thing is, I think things have accelerated since then. So you can put, as you rightly say, you can put extraordinary, like I've in my book I've written about the text messages a little bit, but I didn't want to give them too much space because ultimately there's just nothing of any substance in any of them. And that's another thing that really shouldn't have been in the court case. The court case really should have lasted about a month, and it should have been, here's child A, here's what Dr. Evans and what minimal support he gets from other people has to say about about child A. Here's what the defence and Professor Michael Hall and other experts have to say about child A. Now child B, now child C. Right, you've heard all the medical evidence over a month. What do you think? That's what it should have been. Even that would have been a little bit unsatisfactory because it's harder to get defence witnesses, as we know. But that would have been a more adequate process. There was no need for it to last 10 months. Most of what is in the trial is rubbish. Um, all this nonsense, like they reenacted like Lucy being interviewed. Like why? Why? It
Yeah,
didn't
they
have
do
any
do
merit.
that. They do that. But also, 30 interviews. My God,
Mm,
getting that out. I mean, surely there was a more sensible way to deal with that. But because of the gravity and the seriousness of it, the allegations, it's like, oh, well, let's deal with it all line by line, you know, to the sense, and, until your channel, Chris, like it lost any context whatsoever.
mm.
Um, which is mind blowing, really, and yeah, and we are where we are.
I mean, even the summing up goes on forever. I mean, I made a video the last a couple of weeks back now, just on a bit of Judge Goss's summing up, and my intention was to go through the entirety of the summing up. But even though as I was recording it, I was going, "This is excruciating. This is actually excruciating." And even a couple of people in the comments said, "I mean, that was just painful."
Yeah, I don't
So,
think I got through all of that one, Chris.
I'm
No
gonna.
thanks.
I mean, what chance? What chance have we got? So I
Yeah,
mean, I
and
was looking at.
I've seen not only judges fall asleep in court. I've seen
Yeah.
juries falling asleep, at 3 o'clock, and it's going on. And you get different types of judges, both in the magistrates when you have a district judge and the Crown Court. I was always a very direct, big picture kind of lawyer. I'm like, what I prefer it if a client, if a judge says to me, "I'm going to send your client to prison," I'm like, right, let's have a conversation about that, and this is why you shouldn't do it. And then you get judges, or lawyers that they cover all the little threads that I used to just find excruciating, because
Mm,
I'm much more like, what's the issue? How can we resolve
mm,
it? Let's move
exactly.
forward.
Exactly.
We don't need to do all the stuff. And I would find that the people would fall on one of those two coins.
I mean, I have looked ahead in his summing up, and I've just thought we have to skip this because he goes on for ages until he even gets to child A. He's like, there's still. I mean, I could record. I mean, it probably take another 2 to 3 hours to record his summing up before he even gets to child A. So I'm gonna have to skip that. But it's just that I just why make it? Why make it? I guess the one question that I don't know if you've addressed is, do you think this was a deliberate strategy of the prosecution?
I mean, I don't know of the length of the trial per se, but definitely the whole "there's no smoke without fire"
Hmm.
aspect of, um yeah, the kind of amount of information and the amount of charges. I mean, I don't think they would have got very far, but from the defense, and I know we're going to talk about the structure of the trial in a minute. There'd be room to argue that it would have been so overwhelming for the jury, but then you've got to take into account public costs, that the cases should have been tried a couple of infants and babies at a time.
Hmm.
Try the first few, um and then if there's a conviction, then you go for a trial on the rest. I mean, I don't know, but it it's absurd. Trials of 6 to 8 weeks are exhausting. I was exhausted trials
Hmm.
6 to 8 weeks.
Hmm.
And that was, I was never doing the advocacy. That was me clerking in my earlier years and things like that, and the pressure and dealing with family and the defendant, and all of that. It's like, no wonder there were loads of breaks. But yeah, I don't know if it was a deliberate strategy, but it definitely was, in terms of adding all those cases together, because
Hmm.
that was the only strategy there was.
Hmm. Hmm. Fair comment. So I want to talk about the circumstantial case. So people will be critical of this, and then those that wish to defend the verdict will say, "Oh, just because it's a circumstantial case doesn't mean the person is not guilty." And then when Lucy was initially convicted, I'd often hear the assertion. We don't hear this assertion very much now, I must say, that there was a lot of evidence. That's what people say. Oh, there was a lot of evidence on which he was convicted. But as I and others have pointed out, if all of these pieces of evidence in isolation don't have any value, they don't gain value because there's a lot of them. It's like a typical error of human reasoning. So I just wondered if you'd like to comment on this and the weakness of the circumstantial case in Lucy's trial.
Yeah, and circumstantial cases can be, really strong and convincing, but what they tend to do is have a multitude, I guess, of different threads that have strength. It could be fingerprint, it could be phone records, it could be opportunity. And I guess, the prosecution attempted and successfully did that, in inverted commas, in this case by using a whole load of things that had no real substance. But as we said, it was the sheer volume of it which convinced the jury, which convinced the public, and because it went on for so long. But I think what's really dangerous is cases that are circumstantial, that have the potential for another explanation that is not a crime, and they're called no crime convictions. And I found a recent study, it only came out in 2024 in America, looking at women and miscarriages of justice. So obviously it was of interest to me. But the US has a list of exonerations, which we don't have in the UK, which was interesting. That was news to me. Have to go via the CCRC, the Criminal Case Review Commission, who has Lucy's case at the moment. But 40% of miscarriages of justice in America over the period that she looked at, for men and women, were no crime convictions. And circumstantial evidence comes into play there. And then when she looked at women, who were a very small percentage of that 40%, however, 73% of no crime convictions were women. So there was a propensity more for women to be convicted of no crime convictions. And this circumstantial case, that's built up around them in a single hypothesis. We talked about Donna Anthony, Angela Canning's last time. We've already mentioned Kathleen Foilbig. There are other nurse cases with these where no crime, because remembering that most cases that the police deal with, particularly murders, there is it starts with a homicide. It's quite obvious a homicide has taken place, a
Yeah.
murder has occurred, and then a circumstantial case around that of who, you've got the offence has taken place, you're then looking at who the suspect is. Here you're missing that no offence has taken place and building a substantial circumstantial case, which is a web of related information that leads to a logical conclusion, which can be highly misleading if no crime has taken place whatsoever. And I go back to that time and time again, that the first step was totally missed. So by the time it got to court, it's an absolute mess.
Yeah. One of the things for me is, I mean, I have an amateur interest in criminology, as I've mentioned before. And so I've studied serial killer cases. And of course, as you rightly say, most of the times they're like carrying body parts out of their house. And, the two I studied the most were Jeffrey Dahmer, where he was refrigerating body parts. And the police caught him because they literally went into his flat and it was I think there was one. There was, in fact, one occasion where the police went into his flat and he thought, "I'm definitely going to get caught," and he didn't. They didn't. They didn't manage to catch him, and he managed to get rid of them. But
Yeah.
eventually, they found the body parts. Same with Dennis Nielsen. The reason Dennis Nielsen got caught is he flushed loads of body parts down the toilet, and the drains got blocked. And
Yeah.
he tried to cover it up with KFC. He tried to put loads of because apparently there was a guy doing the drains, and he said there was something suspicious. So Dennis Nielsen who knew what happened. Obviously, he met this guy with the drains, and he said, "Oh, it's probably just someone's flushed a load of chicken down the drain toilet." So he then actively put loads of KFC in there to try and you know
Yeah, yeah, yeah.
not put him off the scent. But eventually, they found the body parts, knocked on his door, and said, "Listen." And,
There's
and
an
it,
issue.
yeah, there's a bit of an issue here. We've found
Yeah.
10 dead bodies in the drainage system, and we know they've come from your flat.
Yeah.
So,
And what's
yeah,
essential in those cases, and we talked about it last time, the same with Peter Sutcliffe, he had an MO, he had a modus operandi, and he's
mm,
found with a weapon in his vehicle eventually. Well, it was around the corner, but is motive. Because for circumstantial case, you need a motive. So, when a family member, which you mentioned last time, is found or whatever, it's looking at who would have an there's a statement, and it's taken me years of criminology and criminal interest, that every act of violence is committed by a perceived injustice that has occurred against them. Or we look at Harold Shipman, there was a financial motive. Even Mary Ann Cotton, who's a serial killer from Victorian times, I think it was Victorian
mm,
times, in the UK. She had a financial motive because women didn't have access to finances at that time. So she was marrying and, bumping off the men and taking their money and their goods.
Mm.
So if you're going to build a circumstantial case, you can't miss out the beginning. Has a crime been committed? And, when you're looking at the who, what's the motive? You
Mm.
don't always need a motive. You certainly don't need one for conviction, but it helps in a circumstantial case because otherwise it's just, I think it's a prosecution tree that it's like the first bit of all of it is missing, and then circumstantial cases become a high risk of miscarriage of justice.
Mm. And another observation that I would make is that those that have killed, particularly in a serial sense, they usually have a surprisingly coherent insight into their own pathology. So Dennis Nielsen, spoke very coherently about why he started doing what he did. Jeffrey Dahmer didn't quite understand why he'd done what he did, but he he knew why. He did kind of know why he wanted to do it, and he explained that. There's just no, like you said, there's a complete absence of any motive here, and there's nothing we've seen in Lucy's writings or comments that's anything other than normal. Let alone is she saying, "Well, I understand why I started doing this, and I understand why I be," there's just no way, is there? I mean, it's
No, well,
very.
and Eileen Warnos, who I mentioned, who was, there's a Hollywood film about her, and it was, I can't remember the actress now, and a documentary and all sorts, and she had severe, mental health and childhood trauma, but she knew why she was doing it.
Hmm,
Absolutely. But I do think that case will be looked on in years to come as an extremely traumatized woman, who instead of being a monster in inverted commas, had years of abuse,
hmm,
and came to a point similar to cases where women, in 30 years of domestic violence, now there's a defense to that, which takes that down to manslaughter
hmm,
because it's years and years of breaking down. But there is a reason why
hmm.
it's happening.
Yeah, absolutely. So we're now going to discuss something that I know people will want to hear about, which is the cross-examination of Lucy by Nick Johnson. So many people have been critical of this. I try to be fair in my criticism because I understand that he's there to do a job, but I do have some criticisms of what occurred in court. I mean, I caught him saying in the closing statement that the parents of Lucy Letby the parents of one of the infants rather, caught Lucy Letby red-handed, which is just categorically untrue. We know for a fact that's untrue. It's agreed evidence. So, but then there's lots of other observations about how he was in his manner, about things that the prosecution dwelled on, like the pajamas and the shredder. So what are your comments or observations regarding the way that Lucy was cross-examined?
Yeah, I haven't had a chance to go through all of it,
Hmm,
but as I said, was it 10 days or something, which
hmm,
is so grueling.
hmm.
um, I think the longest I saw a defendant being cross-examined was 8 days, and he
Hmm.
didn't answer any of the questions. He was answering question with a question,
Right.
but which kept him in there longer than was needed. So what I can see is a very clear strategy, actually, which is quite common in adversarial, cases of this nature, and it started with the comment of weaponizing her behavior. So the first thing that was attempted to he attempted to do or successfully did, as the jury found against her, was to destroy her credibility, and weaponize her behavior, i.e. crying when she was crying, when she wasn't crying, and then commented how long the defense case statement was, again indicating that no smoke without fire. And a defense case statement, for those people that don't know, is a document that's served by the defence outlining the defence quite early on in the case management proceedings, which triggers further disclosure from the prosecution. But then if a client gives evidence and they start departing from that defence case statement, then it's held against them in a similar way to the police interview. He then dives into the fact that she, in evidence, called J Ram a liar, and how many times has she been interviewed? She didn't say that in the interview. She didn't say that in the defence case statement. Her lawyer didn't cross-examine a J Ram on the fact that he was a liar, and from a human point of view, who can blame Lucy for saying that at that
Hmm,
point when she's on trial for multitude of murders and on trial for her life, sitting there for God knows how many months and finally getting her say in the witness box. And I think she, from what I've seen, dealt with it as well as she could. But that strategy was to attack credibility. So it's the first thing the jury remember, because it comes down to whether they're going to believe her or not at this point. He then goes into the, pulling out the police interview things like the shredder and the handwritten notes, and that she had to concede that, yes, the insulin within two of the babies, was too much and had been given to them by somebody, which
Mm.
we know is unlikely to be the case.
Mm.
So we can also see how the police interviews shaped the entire cross-examination, which is what we talked about last time, and my concern of answering that many questions and a King's Counsel barrister sitting comparing it all, pulling out any little tiny thing. And Lucy quite rightly was saying, that they were insignificant things. So she didn't always remember, it wasn't anything of anything. And he was saying they were significant. And then he dives into, baby A, baby B. So it's a deliberate kind of destroying of her character.
Mm.
So the jury potentially don't listen to a lot of what she says after that point.
Yeah, I'm glad that you said that she did well and as well as could be.
God, I think so, yeah.
Well, I'm really glad you said that because I always had that feeling personally, because I don't think people. I mean, I found it incredible that people were saying, "Oh, she was terrible in the witness box. She did this wrong. She did that wrong." These are experienced journalists. In some cases that are saying this. I'd like to see you up in the witness box. See how you got on. They tear you to shreds.
Yeah.
It's incredibly difficult going in the witness box, even if there's no consequences. The consequences are enormous. And she'd been broken down by all the things we've been discussing. This is a
Yeah.
6-year ordeal for her at this point. I thought she gave a very good account of herself. So,
Yeah, I nearly got called to give evidence once because a client nearly waived legal privilege and I was petrified.
mm,
Because I know what happened. I just thought, oh my God, this is going to be, and there were no consequences for me. I mean, potentially there could be, but and I was used to say to clients and preparing them to give evidence, or their character witnesses or defense witnesses, even lawyers don't like to give evidence. It's really, really tough. You're being cross-examined and watched. Public speaking is the second biggest fear, I think,
mm,
or causes the most stress, something like that. So public speaking alone, without knowing that you're going to be attacked, your credibility is going to be attacked. It's going to be in front of other people. You're potentially on trial for, life, life sentence. I mean, I think she did incredibly well under that pressure.
mm,
And again, it goes to that criticizing behavior, weaponizing behavior, defendants full stop, but it does happen more, with women. We saw it with the Johnny Depp and Amber Heard. People are, oh, she wasn't very nice. Oh, I didn't like how she, did this. And Johnny Depp was answering questions really slowly and labored because he's taken so many drugs and drink over the years, but he wasn't criticized at all.
mm,
He was turning up playing rap music like it was some celebrity show. He wasn't criticized at all. And I was like, hold on a minute, this is your ex-wife who's 25 years younger than you, and you have a bit of responsibility here, with regardless of what, and you've brought the case against her in America. So, have a bit of respect. But he wasn't criticized, she was.
I have to say as a disclaimer, I don't know anything about that case at all. So
Very
I
interesting.
literally know nothing about it. I just because it's celebrities, I was like, oh really? Do I really have to hear more about this? Don't they
Yeah,
get
but
enough?
but people that but at least you say that, because lots of people say, and this is other women go, oh well, I don't like her.
Yeah, well, I don't have any views because I know nothing. All I knew was, you know, I just didn't want to hear more about a celebrity being in court. It's just something I didn't want to hear about. So I don't. I must make it clear that I don't know anything about that case at all. I don't even really know what the allegations were. Um, I just know. But yeah, it's interesting to hear your take on it for sure. So let's ask you about something that we have referenced already, which is Judge Goss allowing the prosecution to air its entire case first, basically, rather than taking things on an infant by infant basis. So we don't know this for absolute certain, but this was deemed, at least by one source, as being instrumental in the decision not to call Professor Michael Hall. So, do you have any comment on this, and do you think it was a fair decision by the judge?
Yeah, I mean, I would have been surprised if he had changed the structure of the trial, because my understanding from it, it is that the defense would have made that application again. It was a defense application that was refused. Have I ever seen a judge change the trial structure? No, because the trial structure is the trial structure. Again,
Right,
we've been doing it since 18 whatever, if not earlier. And that is, the prosecution open, they
right.
start their case, they call all of their witnesses, they have evidence in chief with the prosecution first, they're cross-examined one by the defense, and then the prosecution close their case. The defense can make an application, a submission of no case to answer, which is what happened in Lucy's case. And then if that's refused by the judge, which it was, the defense start their case. They may call no evidence. We won a number of trials of just going, okay, well, we're not calling any evidence. The jury can go out on just the prosecution case.
Okay.
And they came back and found not guilty. It's really how the case may have gone.
Can I
And then
just can I just ask why would you do that?
why would you do that? Because the prosecution case isn't strong enough.
Right.
And why put your client through that process when the prosecution case, they have to prove it beyond a reasonable doubt. You don't have to prove your defense. So even if the judge, that application for no case to answer is a legal application without the jury present. So even if the judge goes, well, there is a case that the jury, can decide on. And well, when I did it in magistrates court, and we did it in a good few Crown Court trials, I mean, it annoyed the prosecution no end, because you're more likely to win than not if you do that in the right cases, right? You can't just do it. And there's a lot of potential your client's going to make it a lot worse. So, that they and that could be for a number of reasons. It could be because they're guilty. It could be because they're not very good at explaining themselves. You've got to take into account so many factors. And it is a risk as well. I know certainly we did it on a big case, and I thought the client is going to be really cross with me
Mm.
if they're convicted that
If you
that's what.
lose, it must be awful.
Yeah. So yeah, but Touchwood didn't
Yeah, yeah.
lose on that. So it is a worthwhile strategy, but
Mm.
in this case, Lucy then gave evidence, and then the plumber after her, and there were no other defense witnesses. I'm unsure why the is it Michael Hall was unable to then give evidence on baby A and baby B, or how that worked. I'm not sure. I don't know enough about it, but I would say it
Well,
would be
don't
highly
worry. No one knows,
no.
including him. So,
Yeah. But what I would say, as I've said, it would be highly unusual for the judge to change that structure. But I think the reasoning, and again, I've learned that from your channel, I think, is that it wouldn't be convenient to the prosecution experts for them to
mm,
come back on several occasions, rather than their day or their stack of days giving evidence, being consecutive days, is not a good enough reason to not do it. And that shows an imbalance of power for any defendant. Certainly a young female nurse
I mean, as
with.
well, it was Hindmarsh, who was really not in the case very much at all. And he just couldn't, oh, I need to come in and all at once. And they just said, oh, yeah, fine. I'd be like, if you want to be in this court case, you want to get paid, like turn up when we need you.
Yeah.
You're only in for a few days. It's not like you're there for 10 months.
No, and your inconvenience, but again, it's that institutional power. They're more important than the
Mm,
defendant,
mm,
doctors or, professional experts, and having respect for them and their time, that rather than a young woman who's on trial for her life.
mm.
What is
Absolutely.
more important?
I mean, he should. I mean, in my estimation, if you want to be in a case of this magnitude and you're willing to give expert evidence, you should do what is required of you without question, unless it's so unbelievably unreasonable that no one could be expected to do it. No, and just saying, right, we need you to turn up on a few different days, that is not unbelievably unreasonable. So automatically you should say yes. And if you can't do that, you shouldn't be in the case.
Yeah, yeah,
That's just my opinion, but
yeah.
that would be the standards I would set myself in anything that I did as work.
Yeah.
And if you can't do that, you know, bye bye to your paycheck, as far as I'm concerned. But
Yeah, and again,
obviously,
we go back to especially a trial of that magnitude,
mm, mm.
you're
Definitely in I think it should be across the board, but definitely in a trial of that magnitude. Yeah, that amplifies it further. But I think if you've agreed to be in any court case, there's still, if it's a criminal court case, there are serious consequences for the defendant. Therefore, you should make it your priority to be in court. If you can't make it your priority to be in court, you shouldn't be involved. That's how I feel about it anyway. Um, so let's move on to something else. With that being said, um, yeah. So another thing. This very much relates to what we just mentioned, is that it seems every decision made by Judge Goss in this case went against Lucy. So the way the cases were presented, he then refused to throw Dr. Evans out of the court case. He refused to allow the court to see the RCPCH report. He allowed a majority verdict. He allowed the jury to be reduced to 11 people. He instructed the jury they don't need to be certain about the specific method of murder. Those are just a few examples. So what did you make of his kind of presiding over the case overall?
Yeah. I mean, I would say the jury, again, I go back to, but yeah, we shouldn't be dealing with criminal cases, differently in terms of magnitude, but it's fairly common
Mm,
for, a majority verdict at a certain point. And also, you know, the judge would take into account the public cost and interest at a trial that had gone that far. If a juror's got, long-term health issues or something that's come up, they've got to
mm,
balance all of that, to decide, whether they're going to go ahead, and I certainly had a highly likely guilty defendants, when it's getting nearer to the jury going out for their verdict, deciding that they might know one of the jurors and all sorts of stuff
mm,
to try derail the trial. So judges, would be used to that and having to keep the trial on track. So that didn't concern me. And I've been in lots of cases where, we as a defense team were saying, the judge seems very pro prosecution. Anything we ask for is not happening. They're not interested in our applications, and you kind of get a tone for where the judge is at within the case, and then you may continue making those applications knowing that it's going to fall on deaf ears, and it's really frustrating. So I've been in many of those cases, and again, that is not uncommon. I'm not saying judges are pro prosecution, but you get certain cases where that's the line that they seem to be on. Massive concerns with the RHCP. I can't remember the whole thing of
yeah,
the report from the hospital
yeah.
not being admitted into evidence, because that left, and again, that was a defense application, Lucy, standing on her own with her defense, and it not being given a framework or any institutional support as to the lack of skill and staff on that ward, which was massive. And I know, also, I would say, because yeah, we've talked about her cross-examination, she was forced to concede. Well, not forced, she did concede, which shows what a loyal person she is actually, and she still believed in the work that they were doing, and the ward that, when they were getting super specific about, baby A or baby B, that, oh well, that case, that didn't happen to the baby. Nick Johnson was said, because of staff shortages on that day, did it, or medical error, and she had to concede on that point. I mean, how does she possibly know, all those?
Mm,
So she needed some systemic backup there. And I thought, interestingly as well, that report also referred to the imbalance of power, not
mm,
in those words, but that the nurses didn't feel that they could speak up to the consultants, and things like that, and much more should have been made about that power imbalance. So the jury fully understood the power dynamics that happen in hospital. I've never worked in one. I've had a lot of dealing with them over the last 5 years, due to my father's health. And, I and looking at Lucy's case, fully understand the power dynamics, of who's at the top of the tree and all of that. And I think the jury really needed to see that in context. I don't think that was in the trial at all. I don't think the court took that into account at all. I've talked about the institutional authority. They're all in positions of institutional authority, so they didn't think about Lucy being at the bottom of that, and that report was essential. In terms of Evans, I think there were two times that the judge could have thrown his evidence out. I think the defence made an application not only for no case to answer, but that his evidence was inadmissible and should be thrown out. So that would have been at the end of the prosecution case, I believe. And the judge refused that. And then we had later, when he got the note from the Court of Appeal saying, that he wasn't a reliable witness, and instead of chucking him out the trial or excluding his evidence and telling the jury to not consider it, he just gave them the note so they made up their mind themselves. And again, I think public costs and public interest would have fed into that decision making, and that was, we are where we are because of that decision. And I think because had he excluded the evidence, there would be no evidence, so the trial would have collapsed.
Yeah.
And he would have ultimately been responsible for that and potentially criticised. So, it's almost like pushing the bat over there. And I don't agree with that decision. I think, and I'm sure that the defence didn't either, it's kind of giving the jury too much to deal with.
Well, let's be fair, it's asking them to perform the impossible, isn't it? How can they possibly judge whether or not a doctor who's a specialist in an area that they have no experience in whatsoever is an appropriate witness or not?
Yeah, absolutely. And I think, and we'll get to that. I think it's the next part. He absolutely, in my opinion, it is put an additional direction upon the jury that would have helped them to decipher that. Whether it would have made a difference or not, I don't know, but I'll go through that in a minute. That on top of the fact of all that complexity of 10 months of a trial, when medical evidence is talking about embolisms and insulin and all sorts of ways that Lucy purportedly committed harm to those babies. They were then kind of told, well, they didn't need to know about the method. And then, in a very long summing up, as you've said, just trying to get through and analyze it, it was simplified into almost like three things. Are they sure that something bad happened? Are they yes? Are they sure that someone was responsible? Yes. Well, who? And then they look at Dowie Evans' statistical, non-statistical thing of who was on shift. I mean, what's the point in having a 10-month trial if it was that simple? And they didn't need to know the how. So the combination, and as always with these procedural decisions, it's never one of them. It's all of them as they stand together that caused a huge problem. And that latter one, I believe, was her application for leave to appeal that was refused. And this is where we know that the Court of Appeal and the CCRC really struggle to take into account legal error. They're good when new evidence comes in. We've got a forensic expert who found DNA with somebody else. Well, okay, we'll exonerate that person then. But there's a reluctance and resistance to accept it was only one mistake, so that wouldn't have rendered the whole trial unsafe.
Yeah, I mean,
the prosecution case, when stacked up, it causes an unfair trial.
Absolutely. I mean, you've inferred this quite strongly, but I mean, I will say, for me, I just believe the judge thought, if I throw him out of the court case, the court's going to look ridiculous. I'm going to look ridiculous. We've spent millions of pounds on the police investigation. We've spent millions of pounds already probably on the court case. It's too big. This potato is too hot. I'm passing this over as quickly as I possibly can. And I just don't think he had the guts to do it. And I think objectively, he should have thrown him out 100%. And that's just based on what we knew at that time. What we know now, he definitely should have thrown him out. But
and on top of that, potentially seen the red flags way before it had got that far down the line as well. So, and we go back to where we started at the beginning of this interview, that systemically an individual will be sacrificed for the perceived integrity of the system as a whole.
Yeah, I mean, that's a classic example, isn't it? It's a classic example.
And people in those positions of power don't even realise that's what they're doing. They will justify it in some other way, to to keep the integrity of the system and not cause a collapse, which is the difficulty that we have with the whole of Lucy's case. Is what's going to happen now as all these systems try and maintain that
That they're
they actually
competent.
fairly and properly.
Yeah, yeah, absolutely. So let's talk about our friend Dewi Evans. When I've spoken with you, I mean, pretty much everyone that I come into contact with has found him to be an extraordinary figure. Can you give me your opinion on him firstly?
Yeah, I mean, I had alarm bells before I saw him speak on TV. And then, I literally was like, he is not an independent witness, an expert witness. That's before I knew about any credentials or anything like that. I just found that the way that he was talking, so many of the professionals in this case have spoken about the case. It is the opposite of professional, in my view. When they've been so closely involved in it, it's not for him, as I said with lawyers, it's not for us to decide who's guilty and not guilty. That is the process, that is the jury, and and that's the procedures and that we've just talked about, and the decisions that are made by the court as to what goes in front of them and what doesn't. So they do not always get it right, far from it, but they get it right more than they get it wrong, which is something. But he was on TV saying, well, she's guilty and I win a load of cases, and which experts should be independent. Their duty, overriding duty, is not to be on a particular side. It is to the court, and to assist the court, as is the same with lawyers. And it's not your role to decide guilt or not guilt, and it's certainly not your role to win cases. And I just saw ego, as well as what I know about court trials and the system. Any lawyer, any expert would know within this case that it would have been a massive page count and a good income. And I've actually looked up his company's accounts as well.
And what did you find from that?
About 200 grand a year.
Hmm.
So, and that's over, and I've worked on a coaching consultancy basis for the last 10 years or so. That's, guaranteed work for 5 years, isn't it? Of a certain amount of money coming in.
Absolutely.
So, it's attractive, and yeah.
I don't know
So
why. I don't know why he needs so much money because he only owns one jumper. But he doesn't. He's got a crappy little car. He couldn't even. He clearly deregistered from the GMC because he didn't want to pay the registration fee. I mean, I don't know why he needs all the money so much. But
I think
you
he
know,
mentioned kids in one of the interviews,
yeah,
didn't he? Horses
yeah.
and cars or something. I
They
mean,
must have
my
a lot of horses by now. That's all I can say.
yeah. And and that's not to say, I'm sure he believed his own, ego was telling him that he was right about everything, and still digging his heels in. But it just, it sent massive alarm bells
Hmm.
me of witnesses. And there is a bit of a culture, in legal cases, and you have it in medical negligence cases as well, that the legal system, the medical system work in very different ways. The legal system wants certainty, particularly in criminal cases. And medical opinion is just that, it's an opinion. And they're used to uncertainty, as are lawyers. You're practicing medicine, right?
Hmm.
And that's what we say, we're practicing medicine, or you're practicing law, because you're taking what you know and you're applying it, and you're seeing what fits and what doesn't.
Hmm.
No one knows, with that huge certainty about and any witness that is that certain on all of that is major alarm bells,
Hmm.
rather than their little piece. I just know this. I don't know if she's guilty, but what I know is that this led to this and this, and that's it.
Yes. Yes. Absolutely. I mean, one of the things that has been highlighted to me by a surgeon is that Dr. Evans makes all, you're talking about, practicing medicine, which is essentially the application of things that have been established. If you haven't established it, like you can't go into doctor surgery and say, right, I've got this problem, whatever problem it might be. Uh, and the doctor can't say, oh, why don't you just try this, see what happens. The doctor has to apply established knowledge to the problem.
Mm.
Um, and if they don't have the knowledge, there are circumstances in which they would refer to a specialist. Now, in this court case, Dr. Evans said, oh, yeah, this, he presented things as being established scientific fact or established scientific based on like a base of scientific knowledge. that he cannot do because he doesn't know if they're true. I mean, I've spoken to people and I've cited them in my book where they've just said, look, he can't possibly make this assertion. On what basis is he saying that? Because there's no established precedent for that at all. And yet he presented this as, oh yeah, this is some well-known scientific theory. Essentially, that's what he was saying in court, and it's just not true. So that's really serious. And he definitely has a lot of hubris, but he must by now be realizing that he's in big trouble. We don't know what the consequences are going to be for him, but he at this point he must have serious doubts about what he's done, even if he originally believed himself to be correct.
Yeah,
Um,
yeah, and I think it's that, I think with expert witnesses, and they do, we used to have defense witnesses that we go to. There's a particular psychologist that I used to go to, for kids that don't go to school, and because I knew he was great at, identifying any trauma that had taken place, and when parents are being prosecuted and things like that. But it gets into difficulty if experts think, that they are working for the prosecution or the defense. They've got to be impartial and just stick to what it is that they know. But I think, he definitely saw himself as a prosecution expert,
mm,
and would have built up this confidence, this institutional authority and confidence in giving evidence and winning cases. And when I've seen him talk, almost, liking, enjoying that he can get the better of
mm,
the lawyers.
mm,
And all of that to build up to, again, it's my word of the day, a case of this magnitude, and
mm.
to be involved in that would have fed, an ego.
Yeah, probably doesn't feel quite so good about it now, I would think. Um, so, I mean, even since I've written these questions, it's got worse for him. But um, I mean, you must have experienced quite a few expert witnesses over the years. So, have you? When I began studying this case, when I heard the term expert witness, I had the image in my head of this person who's, forensic, professional, authoritative, all of these things. And Dr. Evans is so far removed from that. It is incredible. So I just wondered, have you ever met or encountered any expert witness who's conducted himself or herself remotely in the fashion that Dr. Evans does?
No, I haven't. Not like that. I mean, what I have done, but the experts need to be impartial, is instruct experts, just on a paperwork basis, and been really unhappy with anything that they've sent back and feel like they've not taken into account the defence at all, or actually properly ruled it out. Again, maybe because it's something that's quite emotive. Like infant and animals and all of that kind of stuff. And I've been massively frustrated, and it is frustrating for the defence and the prosecution when that happens. But you don't get several bites of the cherry. But I've never seen someone conduct themselves in that way, and I'd be concerned, even if if a expert witness was so tied to my client's innocence. Really, I just want them to stick to what they were an expert in and what I'm instructing them to on those facts. But the scary thing is that we've seen it before. And he was given institutional authority to say what he liked without any real backup, and the
Mm.
court supported that, and the prosecution supported that, and the police supported that,
Yeah.
because he did look and sound the part to a certain degree,
Yeah,
which
I'm
is
not sure how this happened, but from what I've seen from him, but there you go. Obviously, they were convinced. But yeah. So you've referenced, when we were talking previously, you've referenced other historically problematic experts, such as Meadow and Southall. Do you see clear parallels between them and the cases they worked on and Dr. Evans and the Lucy Letby case? And if so, could you expand on this?
Yeah, I don't know that much about Southall, but I need to
Hmm.
look him up. But you
Hmm.
know, Roy Meadow, absolutely. And the minute I heard about Lucy's case, I was comparing the Roy Meadows cases of the baby shaking cases, the late 90s, early 2000s, and again his institutional authority and overconfidence to assert facts that were not backed up in any way, shape, or form, and for that to be persuasive, and almost to be on a bit of a one-man mission. to convictions
mm,
of a certain nature, and
mm,
again feeding their ego in that way. And he was connected with Martin Warplatt, who was first peer reviewed Dowie Evans um, evidence. So and I didn't know that when I felt that there was this real connection between these types of cases. And Roy Meadow also connected to the Beverly Allitt case, which is apparently a case that Lucy learnt about when she was studying to be a nurse. That I think the prosecution, I don't know if they did it in the trial, but indicated that that might have been where she got these fanciful ideas from.
mm,
Quite the opposite. I think it's some rogue experts with big ideas that are not really backed up to you know I don't know, save the world in some way, shape, or
mm,
form, to make these kind of allegations. Beverly Allitt is still in custody, and she's made admissions after her trial to some people say so she can be placed in a secure unit rather than in a prison, because there's more support and privileges there, probably because there's been some kind of mental breakdown after, if she's and I'm not saying whether she's innocent or not, it's not for me to decide. But I think when cases like Roy Meadow, and there was a stack of cases that he'd given misleading evidence upon. And what I'm going to say is, I don't think these experts are deliberately misleading. They believe in their own BS, if I can put it that way, that
mm,
they know everything, and they can function within a system that will back them up, and they know that. Is that all the cases should be reviewed, because if they've done it in
mm,
one case, then the Court of Appeal and the system should be going, right, we now need to look at all of these cases. We don't need to wait for a lawyer to be instructed. In fact, we should maybe appoint one, or write to that person in custody and say, would you like to appoint a lawyer because we need to review your case? But no, the system's not going to take responsibility
yeah,
on that
absolutely.
level, and that concerns me. And interesting, I was going to mention actually the case of Louise Woodward. I don't know if you know the nanny in
Yeah,
America,
yeah,
who was 18. There's a documentary on TV about her case, and obviously it's all on video, and it was a Dr. Barnes, who ruled out the defense of that there was a previous injury that had kind of ruptured, or in another baby shaking case, and he's come out later and said, I wouldn't give that evidence now,
mm,
uh, that I was sure beyond all reasonable doubt it wasn't an old injury. And that's because of the training they have with the triage of
mm,
symptoms that allegedly occur in baby shaking cases. So he's come out and said that. But again, he's within a system that will back him up,
yeah,
um, that he's right. And we, again, not to put the gender point on it, men are more likely to assert things when they're
mm,
60% confident that it's
yeah,
true,
yeah,
and apply for jobs when they're 60% of the
yeah,
skill set. Women wait until they're 90, 95, 99, and there's still
mm,
self-doubt, because as we were saying, with the court system, medical system, lots of systems, women don't belong there very originally. So we're aware of that, and we make sure we're 100% a lot before we put ourselves in that position, because also when women get things wrong, they're torn down
mm,
quicker
mm,
and easier. So I think the system really has to ask the question about who we're giving an institutional authority to, and why are we not, putting extra safety guards in because they look and sound the part. And I'm not talking about what they're saying. I'm saying what they look like and what their accent is, or whatever.
mm.
They've got the fluency to make anything sound convincing.
Yeah.
If
So,
not,
so we talked about this before we started recording, but just to back up what you're saying, I was saying to you, if I had been in Lucy's position, and I've often thought this, I'm glad I've spoken to you, and I'm glad I've spoken to others now, but I've often thought that Lucy's reaction is a very kind of typical female reaction of starting to feel guilty about it and starting to, feel put upon in a way. Whereas if it had been me in that situation, I know for an absolute fact, I would be like, how dare you? How dare you treat me in this way? How dare you throw me off the unit when I'm innocent? How I'm the only competent person on this unit. What the hell are you? And I would put it more strongly than that, as I did when I spoke to you to when we weren't recording. But and then the second thing is, once I'd won my grievance proceed, Lucy almost wants to go back onto the unit and feel accepted again. Almost like to feel accepted by her workplace where she's been before. Where I would be thinking, if you think I'm going back on into a workplace where people have accused me of murder with no evidence, where they've tried to destroy my life, you think I'm just going to toddle on back and go, oh, hello, yeah, sorry, it's just a bit of a shame that you said I was a murderer, but hey, let's just put it behind us. There's no chance. There's absolutely no chance. I would say, you're going to suffer now. You're going to suffer because of what you've done, and I'm going to take you down because I've got the
Yeah.
power to do that now.
Yeah,
And
it's that, and yeah, she's gone into, again, we mentioned her age and things like that last time, that she really felt she belonged there, so her loyalty, you know uh, as well as psychological pressure, totally heartbroken by the allegations,
mm,
and as I said, even in cross-examination, she's still backing up her ward. I mean, I mean, it's
yeah,
admirable. I mean, I
even
would.
even in the police interview, she won't say anything against other nurses or people on the unit.
Yeah, yeah. They're totally thrown under the bus, but she refused to behave, in a similar way, which is admirable, but it didn't
Mm,
get her where she needed, to go. And again, I would push back, but again, my training as a lawyer and things like that is to be like that.
mm,
Uh, but I know many women that I've coached, over the years, and it's that internalizing that self-blame, and, oh, if I do something
mm,
different, I could do, etc., etc., etc.
mm.
And yeah, and this isn't, I know we were talking last time about misogyny. This is about power imbalance. That's all. It's not about
Mm,
hating women. It's just, it
mm,
is about belonging in systems, and it is about having your voice heard and having institutional authority,
mm.
and all of those things, which definitely impacted this trial.
Yeah,
And it saying that it impacts all trials, that there is an imbalance of power. And I know people
yeah,
have talked about Ben Geen and Colin Norris, and their convictions still stand. And men as nurses actually stand out because they're men, because it's not a usual position for men to be in. It's a very small percentage. So there's still a sense of othering, that they might not necessarily belong. So it's easy to put blame on if there's, systemic failure there. I don't know enough about their cases, but that's certainly something to be considered.
yeah. So something that I'll just mention very briefly that I forgot to mention is that you mentioned this case in America where the expert said, "Well, actually, now I know that what I said at that time was wrong." That also happened in the Colin Norris, Colin Campbell case, where Vincent Marks, Professor Vincent Marks, was an important expert in that case, and then later on he said, "Well, actually, I think what I said was wrong." But that hasn't done Colin Campbell any good yet, unfortunately,
Yeah.
'cause he's still in prison. But hopefully we can get it reassessed, and at some point in the future, obviously he's suffered enormously already, but that's a side issue, unfortunately. So I want to discuss. This will take a little bit of explanation, but many viewers may have seen a video that I made a while ago. I believe it was called "Did Dr. Evans Just Drop Another Clanger?" Which of course he did. In this video, I examined a letter that he'd written. Of course, he's written more letters since then, and he's completely forgotten about what he said in that letter. But in this particular letter, he claimed that he had spotted that the police, Crown Prosecution Service, and prosecution team had made a mistake with Child C, mixed up the dates, and that he had spotted this in court and corrected it. Now, I've established already that this is categorically untrue, so we don't need to assess that any further. What I wanted to ask you is is this even feasible legally? So it seems to me that if you spotted a major mistake in the prosecution case, there'll be disclosure issues. If you corrected a mistake, you'd have to go through processes that are established. It wouldn't be possible for an expert to just start correcting fundamental aspects of the case that change the allegations without even informing anyone. Obviously, he didn't even do that anyway. But can you clarify that and give me your thoughts on this?
Yeah, and I watched your video. I think in the first instance, and then again when I know you wanted me to have a look at it for this question. I mean, what the hell was going on? I was confused for some of it, let alone the jury, as we were saying,
Mm,
over 10 months of this back and forth, and the defense did the best they could with it, but it was certainly messy. And I know, I think you were talking about in that video that it could have raised issues of disclosure, and absolutely, in terms of the statutes, the Criminal and Procedure Evidence Act of, I think it's 1990 something or other, absolutely, yes, it could have raised disclosure, but what disclosure, I would ask, that would be helpful to the defence? So I don't know if they paused, etc. An application could have been made to amend the indictment, but what I found was important, and that is important to what we've just been talking about, is for me it should have triggered the judge potentially making a case law direction. But in the summing up that we talked about, that was very lengthy, because we have statutes, the things that the government, that goes through the Houses of Parliament. But case law is when cases have gone through the Court of Appeal because there's been a failure somewhere, and that and then that case becomes a precedent for the future. If something similar arises, then the court can give the jury a particular direction, or sometimes we use them in the magistrates court as well. And this, it's a Polish name, it's a Deluga's style direction, which warns the jury if an expert has changed something, fundamental about what they were saying, or added something into their evidence, which is similar to what the prosecution accused Lucy of doing, which you called J Ram a liar, right? Oh, you didn't say that before, you're saying it now. And that's classic for adversarial proceedings. But if an expert witness does that, this particular direction is a warning to the jury before they go out and deliberate that experts can be wrong, that their expert opinion is an opinion, it's not a fact. So within that, what the court is doing, and I actually think this direction should be made in every single case. I don't think there should be something that's been potentially shaky in the evidence in order to do that, because as we've been talking about institutional authority, doctors and people that have pieces of paper after their name and particular accents, whatever, are given greater weight and greater credibility than they should be. And sometimes, and I think quite often, a jury will consider what they're saying as facts. It sounds scientific, therefore it must be a fact. Whereas they should be told that it's just an opinion, and it's up to you to decide whether you accept that opinion.
Yeah. There's I've seen like videos of people going around. I think sometimes these ambush things they do with microphones and stuff are a little bit unfair. But I've seen videos of people saying we've got to ban sodium chloride. We need to ban it as soon as we possibly can. Do you agree with this? Of course, that's salt. So and you can fool people because chemical names can sound very intimidating, for example. So yeah, I agree with what you're saying for
Yeah,
sure.
we had a similar one. I tell you what, the magistrates never understood it, and I used to find it really frustrating. Called the Turnbull Guidelines. It's another case law. That's when it's a mistaken eyewitness identification, and the direction is something along the lines of a credible witness can be an incorrect witness. So they're credible, they believe what they're telling you, but they're actually wrong.
Mm,
And I had that with the client on CCTV. A witness said it was my client. I was like, you wouldn't know if that was your own mother, father. It's too dark, you couldn't possibly say.
mm,
So I said, and this was just in the magistrates court, but they're mistaken. They can be credible, you can believe them as a
mm,
witness, but they're actually mistaken because you can see that CCTV and you wouldn't know if that was your husband. And they went off and they came out and said, oh, we found the witness to be highly credible and found my client guilty. I was like, you didn't listen to the
mm,
direction. So magistrates and juries don't always understand the directions even when they're given. It's so frustrating.
mm.
But this is when lawyers have to move away sometimes from the technical legal language and make sure these things are being understood. And how lost would that direction been in a massive summing up?
Oh,
The main part
very,
of the
very.
case.
It would be like looking for a needle in a haystack,
Yeah.
given the length of the summing up. Yeah. So let me just contextualize this for people as well. So the important thing to remember about this is, of course, this was a case in which there were many alleged murders and alleged attempted murders. But in the case of Child C, imagine if that had been a standalone case in a court. So most court cases about murder are about one murder, presumably, I would assume that
Yeah.
you get some serial killers, but most will be about one murder. So imagine if in a normal court case, suddenly the major expert on which the whole thing hinges said, "Oh well, actually, we don't think the defendant attempted to murder them on the 12th of this month. We think they attempted to murder them on the 13th instead." And then not only that, but he's saying that the prosecution mixed the date up, and that's the only reason why it's not the 13th. I mean, this is obviously he never even said this anyway, but I mean, there's just no way that that should be allowed. I can't see any conceivable way that should be allowed.
No, something funny, it happened, something similar happened in the Edith Thompson case that I mentioned. It was because part of the allegation was something about, her and Freddie Bywaters, her lover, as it were, had met up, and the prosecution case was that they colluded, right, to kill her husband. And then it turns out, like halfway through the trial, whatever, the date was wrong. But everyone just brushed past it. It was like, oh well, it doesn't matter if they had the meeting or not. They still colluded because we've got her letters, even though they have no nexus to the offence whatsoever. So, it's the courts can overlook, these things. And the more complicated it gets, the more likely it is to be seen as small fry when it's big fry, and it contributes to a expert witness not being credible.
Absolutely, undeniably, I would say. So
But they can be credible and they can still be wrong.
yes, yes, that's very true, very true. So I want to finish by just asking you a couple of general questions. The first one is maybe I think a very difficult question to answer, but I'm sure you'll have a good answer. How do you feel about the current state of the criminal justice system?
Yeah, I mean, it's not good, is it? Even though I've been out of it for a while with, 3-year backlog of trials, which we've talked about, delayed justice isn't justice. The getting rid of jury trials, I think that's come in for 3 years or less, where a sentence. And I know lots of people are not fans of jury trials, and particularly after Lucy's case, there is an argument that more technical trials need to be dealt with by judges. But I think we've also explored today that procedurally, what goes in front of the jury is absolutely critical in those decisions that are made. It's not actually the jury getting it wrong; it's how it's presented, in my opinion, and it is a very important as a systemic an institutional check that members of the public are holding that system accountable and coming into it, rather than just, technical lawyers and all of that kind of stuff. So that's an issue. Prisons totally overcrowded, rehabilitation doesn't work. Most people in the criminal justice system are not trauma informed, and we go round and round and round an old archaic system that isn't fit for the 21st century. So it needs a major overhaul, as well as underinvestment, and underinvestment in defence lawyers, solicitors in particular. Barristers, I don't think there's so much of a gap, but solicitors, there's not there's a gap. People are crying out. And for me to go back into practice, and all of that, because there's not a lot of people coming through, because
Mm.
it's not the job that it used to be.
So really, so if you had people ask you to come back,
Yeah,
oh really, really, that's
particularly now because I'm
interesting.
talking about this case.
Yeah, yeah. Your
After
profile's
I've been
about
quiet for a while.
your profile's about to go up.
Yeah, yeah,
Yeah.
yeah. It's yeah, and it's funny because me and a very good friend of mine, we were trainees together, and there are some people coming in. There's not many people coming in younger than us, in the job, because it just got so bad for such a long time. And I was talking to someone the other day, and they said, oh, a load of the legal aid lawyers haven't been paid for ages, and all of that kind of stuff. It's not in a good way, and yeah, it needs to be rebuilt from the bottom up, really.
I think you have similar issues in the medical profession because I had a friend who is a lot younger than me, and he qualified to be a doctor a couple of years ago. I haven't seen him much since then. And his parents were doctors, and they just basically paid him through the whole thing. And we were having a chat about it, and I was saying it just wasn't really an option. I mean, not that it was a career goal for me or something I wanted to do, but I never even considered being a doctor because I just don't see any way I could fund it. And that was 20 years ago now. I mean, he basically agreed if I hadn't been paid through it, I wouldn't have been a doctor because it's so like think of the accommodation involved. That it's just so difficult. And then you don't even start on obviously doctors make good money eventually, hopefully, but it's not like you start on some super salary. You don't. So
No, and so young barristers, I mean, they earn an absolute pittance,
mm,
and a lot of law firms were taking on paralegals and not trainees because they set a minimum wage for trainees, and you can employ a paralegal for cheaper. And certainly for legal aid firms, because they've not put up the rates for God knows how long. And there was an article in the Law Gazette about the cost of Cadbury's cream eggs when they set the legal age rates and how much they've gone up by and how many you'd be able to buy and that kind of stuff. There almost wasn't, that much choice. So,
Mm.
firms need money and things coming in to be able to train staff and bring them in. So it's difficult and very much the same as the medical system. And also with both of those systems, and as I said, I've had quite a lot to do with the medical system recently, and there's very strong parallels, with the professional role of that nature, that nobody seems to be case managing in the way that they did when I was first in practice, expecting computers to do it for you. And, that overwhelm that we talked about is absolute chaos,
Mm.
across the board. And, computers, AI, all of that, you've got to have a human being who understands and is dealing with their patients or their clients. And it seems like that's gone totally out of the window, which is causing, absolute disruption, that we've lost how to function at a basic human level with that
Mm.
integrity and also that accountability that's so fundamental to those institutions.
Yeah, absolutely. So the very last question I'm going to ask you is, in light of what's happened recently, yesterday, as I'm recording this, how do you feel that Lucy's case stands, and what are her prospects for exoneration?
Yeah, I think, this is the best position that she's been in, when she's got 15 life sentences. That's not a good thing to say, is it? But in terms of, this is the only decision I think that has gone her way throughout the very beginning, of the case. So that is a positive step in the right direction. The CCRC, hopefully hearing from them, I think around the summertime, and hopefully that will move things positively forward. And I think, Mark McDonald has done an amazing job, as have all the medical experts and the panel, and the way he's gone about it, despite being criticised by Liz Hull for using the press, the very system that she
Mm.
has built her career on, to get that public interest and to keep this conversation in the public eye, which you doing an amazing job of that as well, Chris, which is so important for miscarriages justice cases in the past, that people just aren't forgotten about. A little bit like Beverly Allitt, for example. I think she's only been talked about because of Lucy's case, and I don't know. As I say, it's not for me to decide innocence or guilt, but there's certainly concern, with the experts that were involved in her case and her motivation for confessing to additional crimes and things like that we see people do when they're under pressure. So, the press and now independent channels have, so much to add to keep the conversation going and putting pressure on the system to look at this properly, and not to, as we've said, uphold the integrity of it when everyone can see straight through it. I mean, that's not everyone, but it's certainly turning in that direction. And only when that pressure amplifies, we hopefully get to the right decision. So I think she's in the strongest position that she's has been, but there is a long way to go, obviously.
Yeah, yeah, absolutely. So that's great. Thanks again for joining us today. We really appreciate it. It's been very interesting as always, and hopefully I'll speak to you again in the future. Thanks for everything that you've done and for your time. They're very much appreciated. And I know you've got some stuff coming up that I don't know if you want me to mention. Do you want me to mention that?
Yeah, you can do. Yeah.
Why don't you tell us about it then?
Yeah, well, I've been busy writing an article about the imbalances of power at Lucy's trial, and we've written I've written a long one and a shorter one, and we're hoping that the shorter one will come out around International Women's Day to raise more awareness about the case, and the inconsistencies that have happened. And that's ahead of your book coming out in June, so it's all those little things, and well, not little things, they're big things, but that are meeting different audiences and keeping it in the public eye. So hopefully we will get that in some kind of publication. But it's been a lot of research and work, and your channel's been really helpful, in pulling out a lot of the context and the facts that have been missed within the public, within the trial, within the books that are out there already. So yeah, I'm looking forward to sharing that.
Yeah, absolutely. So thank you for doing that, and thanks again. And I'll keep in touch. I'll no doubt speak to you again soon, and maybe in the future we can have you on again.
Yeah, thanks so much, Chris.